Hey everybody, Lieutenant PK here. In today's lesson, I'm going to be talking about when you can lawfully enter a dwelling without consent to arrest someone inside. As law enforcement officers, we routinely go to people's homes to make arrests, and everything's fine when they're cooperative, open the door, or come outside. But when they're not cooperative, when they don't want to allow you inside, you have to know when you can lawfully make an entry or when you have to back off and come back with an arrest warrant or possibly an arrest warrant with an additional search warrant. Whether or not you can make an entry depends on a lot of different factors, so we're going to break this down into categories: felony charges, misdemeanor charges, fresh pursuit, and arrest warrants. Before we jump into those, I want to share a short quote with you from the United States Supreme Court. "The physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed." Wow, chief evil. That's some pretty strong wording, but this quote helps you understand as a law enforcement officer that anytime you enter a dwelling, whether it's to make an arrest or do a search, with consent and especially without consent, you can expect that case to be scrutinized. The first category I'm going to talk about is making an entry without consent into a dwelling to make an arrest for felony charges. In our scenario, our suspect has a complaint affidavit against him for burglary of a dwelling, F2, and grand theft, F3. Officers respond to the suspect's residence to arrest him, knock at the door. The suspect refuses to come out and will not allow the officers inside. So the legal question is, can an LEO make a warrantless entry into a dwelling without consent and without exigent circumstances in order to make a felony arrest? Go ahead and take a stab at this one yourself. Don't worry, I'm not grading you. Ready for the answer? No.
Yes!
An LEO cannot make an entry into a dwelling, and that can be a house, motel room, apartment, and even a tent in some circumstances, for the purposes of making a routine felony arrest. Now, this is not new case law. The United States Supreme Court ruled this in Payton versus New York back in 1980. Let's talk about that phrase that the United States Supreme Court used in their ruling, a routine felony arrest. Some law enforcement officers, when they learn that, start to rationalize what would be routine and what's not. They may say, well, a burglary could be routine, but what if it's a crime of violence? What if it's an aggravated battery? Can I just make an entry then? Well, the answer is in the details of Payton versus New York. Now, the U.S. Supreme Court looked at two cases, but one of those cases was the murder of a gas station attendant. In that case, detectives had developed probable cause to believe that the suspect committed that murder, so they went to his house to arrest him. They went in without a warrant. He wasn't home, but they recovered evidence. The U.S. Supreme Court said that that was still a routine felony arrest. There were no exigent circumstances. What this case shows us is that although you might have a very serious charge, like in this case it was a homicide, the gravity of the offense alone is not justification to make that warrantless entry without consent. Let's move on to non-consensual entries into dwellings to make misdemeanor arrests. Now, this one should be really easy after we just covered felonies. In this scenario, our suspect has a complaint affidavit against him for battery domestic violence, an M1. The suspect in this case no longer resides with the victim, and prior to law enforcement arriving at the scene, he flees and goes back to his apartment. Law enforcement officers go to his apartment, knock on the door, know he's inside because he yells through the door, "I'm not coming out." The legal question is, can an LEO make a warrantless entry into a dwelling without consent or exigent circumstances to make a misdemeanor arrest? As I said, this one should be pretty easy after we just covered felonies. No.
Awesome!
An LEO cannot make an entry into a dwelling without consent to make a warrantless misdemeanor arrest, and there is no exception for domestic violence. For some reason, some law enforcement officers seem to think there is. Now let's talk about fresh pursuit. We're going to break this one down into felonies and misdemeanors. Let's go back to our first suspect. Remember the fellow who's wanted for burglary of a dwelling? Well, in this scenario, he's standing outside when the police show up at his house to arrest him. Our suspect tries to defeat the arrest by running back into his house, which brings up our next legal question. Can an LEO make a warrantless entry into a dwelling to make a felony arrest in fresh pursuit? The answer is yes. The United States Supreme Court answered this one for us in U.S. versus Santana in 1976. A person cannot defeat a warrantless felony arrest that was set in motion in a public place by retreating into a private place. Let's talk about that part of the ruling, public place. If you remember in our scenario, our suspect was standing in his driveway when law enforcement arrived. Although that's his private property, he had no expectation of privacy in that location. He could be seen and heard as well from that location as if he was standing in the street. So for the Fourth Amendment purposes, he was in the public place when police set that arrest in motion. Now let's move on to fresh pursuit of a misdemeanor. In our scenario, our suspect is wanted for petty theft retail, an M1, and she's standing outside when law enforcement arrives at her house to arrest her. Our legal question is, can an LEO make a warrantless entry into a dwelling to make a misdemeanor arrest in fresh pursuit? Given the circumstances of this particular case, the answer would be no.
Amazing!
You may have noticed I put a little asterisk after the word no, and that's because although we can't make an entry in this case, there are some rare circumstances when you will be able to make an entry in fresh pursuit on a misdemeanor. Let's start by explaining why you can't make an entry in this case, and that comes from a 2017 ruling from the Florida Supreme Court in State v. Marcus. Fresh pursuit does not justify entry into the home for a non-violent misdemeanor. So you may be asking yourself, does that mean the Florida Supreme Court says that I can make an entry in fresh pursuit on a violent misdemeanor? No, they're not saying that at all. And this is important. Even a misdemeanor involving violence is not sufficient in itself to justify an entry. There must be additional exigent circumstances. And I'm going to tell you, that's not going to be easy. In fact, lawful entries to make a misdemeanor arrest are extremely rare, so it's always better to err on the side of caution and not do them. That's the end of part 1. In part 2, I'll be talking about entries into dwellings when you have an arrest warrant. That's it for today. Stay safe.